Thank you to the EUIPO for organizing these webinars. Thank you to ECTA for giving us this opportunity and also for the support in organizing the substantive matter at the basis. So I will start with my first slide. Why this seminar and why today? So we look at the implementation timeline, and as you know, in 2015, trademark directive was adopted, so-called second directive or new directive, and member states were required to transpose the provisions of this directive into the national laws by January 2019. With the exception of Article 45, which had a longer implementation period ending next January 14, as it is exactly the provision regarding administrative procedures for revocation of trademarks and the declaration of invalidity. Of course, this required a longer period because of the organization behind it. So we are now at 1 month from this big date. Apparently only Italy, Spain, and Malta have not yet fully implemented Article 45. In a number of jurisdictions, for example, France and the Benelux, the provisions were put in place and implemented following the trademark directive, which means that they did not have these administrative procedures before. And then there is a third group of countries, of member states, where administrative proceedings were already available. But still, in many cases, they needed to be adjusted in order to cover all the mandatory invalidity and revocation grounds. Incidentally, I will use these words like member states and national, and of course, they are meant to cover the Benelux. I trust that my fellow panelist, Carina and Gommers, will not mind. It's just for the sake of simplicity while I speak. So at the time when the directive was adopted, there were voices from practitioners and also user associations worried that some solutions that are available, successful, and efficient at the EUIPO level were not necessarily applicable at a national level due to possible lack of resources and lack of expertise of the national IPOs. Now, in some countries, it is too early to say whether these concerns were founded, of course, especially in the countries where the system has not yet started. In others, there is already a discrete body of case law and some assessments can be made, and we will see later. So we will go to the definition, a slide with the provision, with the first part of provision of Article 45. In the next slide, please. So this is the first part, and what we need to look at, let's say, main words are administrative, efficient, expeditious, and revocation and declaration of invalidity. So this is what Article 45 requires the member states. What it makes this article particularly interesting is that it applies to an area, it pertains to an area where there is a very low level of harmonization. There was a very low level of harmonization before the implementation of the directive, but there still is, both on a substantive level and on a procedural level, as we will see. There still are a number of differences, differing practices between the countries. So the provision is meant, of course, to strengthen the rights of the trademark owners, to bring simplicity, of course, to reduce costs. Now we will look more in detail at what was harmonized according to Article 45 and what is still left to the discretion of the member states. So in the next slide, we will look at the single areas. So Article 45 of the directive, I assume that you have it at hand and you can take a look if it's necessary. So it includes, as you will see, the possible revocation and invalidity grounds. Now, as far as revocation grounds are concerned, the directive is pretty straightforward. So we have absence of genuine use and acquired a generic or acquired a misleading character. These are all mandatory grounds as such, and in addition, it is also mandatory that the administrative proceedings are available for both. When it comes to invalidity, declaration of invalidity grounds, the structure is a little more complex. We have absolute grounds for refusal of or invalidity, and typically this will be lack of distinctiveness. They need to be available as grounds for administrative proceedings. And this applies both to the absolute grounds that are mandatory under the directive. So I'm talking of Article 4.1 and 4.2, but also to the grounds that are optional, those provided by Article 4.3. So what does this mean in practice? This means that the grounds provided by Article 4.3 are not mandatory, but once a member state decides that it will introduce them, then it also needs to make administrative proceedings available for those grounds. When it comes to relative grounds for refusal of invalidity, the member states have more freedom. So those relative grounds that are mandatory under the directive, so typically risk of confusion, delusion, prejudice to the reputation, they also need to be made available at an administrative level. On the other hand, those relative grounds that are optional as grounds, typically non-registered marks, right to a name, a portrayal, or conflict with other IP rights, these may be reserved to judicial actions only. So the member states will have an option. So before I go to the next point, I move to the next point. Again, I would like to insist on this word optional because it's used in 2 different ways. So I would like to make it clear because I understand it might be confusing for those who are not very familiar with the directive and the implementation. So there are grounds that are optional in the sense that the member state may or may not decide that this is a ground for invalidity in itself, for example, non-registered trademarks. Then there are grounds that the member state may decide to make available only at a judicial level. So this is a second sense of option by the member state. When we come to the standing, the issue of standing has been fully harmonized. So any natural or legal person is entitled to file an action for revocation or declaration of invalidity based on absolute grounds. This comes as a novelty for some jurisdictions where there is a general principle according to which legal interest is a requirement. In Italy, for example, the IP code still includes legal interest, but we do not yet know, it is still unclear whether this must be proven somehow or it may just be declared for the sake of complying with the provision. The venue, so again, administrative versus judicial. So the directive does not impose that the IPO are an exclusive venue for bringing actions for revocation or declaration of invalidity as a main action, not as a counterclaim. Even though we will see with Paola that many made this choice. So the competence of IP courts in principle in these matters could be maintained. And there are arguments in favor of maintaining like a binary alternative system. Well, one of the arguments is that maybe more complex matters would be more favorably decided before a court rather than before an IPO. Also, there's a rather common scenario in which invalidity or revocation actions are brought together with infringement proceedings, which of course is not possible before the IPO. And then another argument that was brought, another concern of the practitioners and user associations when the directive was adopted, is that many IPOs might not have the necessary skills, the necessary financial resources, the necessary organizational resources to properly and timely handle such matters, particularly because the directive expressly requires that these administrative procedures are efficient and expeditious. So somehow they are meant to follow an EUIPO model. So overview of what is happening now of the webinar. So Paola Ruggiero from INTA now is showing us some differences between the member states on some of the points that I mentioned and others still. And these are intended to be a sort of a practitioner's checklist. What do I need to look at when I am considering some invalidity or cancellation action in a jurisdiction that is not my own? Carina Gommers, first vice president of ECTA, will present some statistics and case laws from the Benelux to show us how implementation has worked out in practice. And finally, Andrej Bukovnik will guide us through the issue of bad faith. This is a hot topic, I believe, in view both of the common practice, CP13, but also because in many jurisdictions, this is the first time that the bad faith ground is made available at an administrative level. So it is very likely that it will be much more invoked now than in the past. So I think it will be interesting to hear Andrej. So for the time being, I leave the floor to Paola.
Thank you, Mara. Thank you, EUIPO and INTA, to give me the opportunity to attend this seminar. As Mara said, in order to understand where we are now, we prepared some questions that we circulated amongst the member of ECTA and INTA. And I have summarized the answer we received up to now in the following slide. As stated by Mara before, there are now only 3 countries where the directive has not been implemented yet. Italy, where the implementation will be in force since next December. Spain, where it will start on January 14 next year. And Malta, in respect of which, unfortunately, we do not have any news yet. The answer we received up to now are related to the 7 countries that you see in the slide, plus Benelux, Hungary, Bulgaria, Portugal, Slovakia, and Ireland. So when I do any reference to all the countries, is not related to all the 27 countries, but only to these 13 countries. The above said, let's start with the first slide, and you see the first question is if invalidity revocation procedure can be filed alternatively before the IPO or the court. Here we have a group of countries such as Spain, Estonia, Poland, France, and Portugal, where this action have to be filed only with the TMO. But the filing before court is admissible only as a part of a court counterclaim in the case of an infringement of trademark. Some countries such as Slovakia, Czech Republic, and Bulgaria, where the action can be filed only with the TMO. There is an exception for Czech Republic, which is under the EUTM regulation. The Czech court would have to deal with a counterclaim for revocation or declaration of invalidity of an EU trademark pursuant to Article 128 of EUTM regulation. Anyway, the colleagues who gave us the information told that he witnessed such a counterclaim only once in practice, and that the Czech's judges were not happy at all about this. Then the remaining countries, such as Italy, Germany, Hungary, Finland, and Benelux, the action can be, in this country, the actions can be filed alternatively before the TMO and the court. Anyway, in Germany, an invalidity action based on absolute ground of refusal can only be filed before the trademark office, while in Italy, the proceeding before the trademark office are considered not processable in case an identical proceeding is pending or has been initiated at the same time before the court. Going to the second question, we ask if after an unsuccessful invalidity revocation procedure, is still possible to apply for invalidity of the same registration on the same grounds before the court. Here the answer is almost no for all the countries, but with some exception. Indeed, in Germany, an invalidity request based on prior rights would be considered inadmissible if an invalidity procedure on the same grounds and between the same party is pending before the GPTO or the final decision has already been rendered on the matter in dispute. In Estonia and Benelux, it will be possible. In Ireland, it is possible only if the invalidity was filed before the IPO. And in Bulgaria, only if the invalidity was not filed on bad faith grounds. With the third question, next slide, please. Thank you. We asked if administrative invalidity revocation procedure are provided under national law for all mandatory grounds under the Trademark Directive and or for any additional grounds such as non-registered trademark rights, right to a name or portrayal, copyright, other IP rights, and so on. To this question, the answer was mainly yes for the majority of the EU countries, where the action can be based then on all grounds for revocation, all the absolute ground for invalidity, and all the relative grounds mentioned above. Anyway, there are some exceptions, and for example, in France, the court remains exclusively competent for invalidity based on an infringement of a copyright, a design, or a personal right. In the context of legal proceedings, counterclaim for invalidity or revocation made in absence of any previous referral to the trademark office, whatever the ground invoked, or any claim or invalidity or revocation, regardless on the ground invoked, but when such a claim is related to an action falling within the jurisdiction of the court. Let's say an action of infringement, unfair competition, contractual liability, and so on. In Italy, also we have exception because court remain competent for earlier unregistered mark, right to a name or portrayal, copyright, other IP rights such as company name, domain names, applicability of Article 6bis of Paris Convention, well-known trademark in a third country, other than the bad faith, where examination run on multiple factors. Carina, can you tell us which is the situation in Benelux?
Yes, of course, Paola. In Benelux, we would have the short answer yes, with exception. So you can invoke additional grounds. What you cannot base your action on is a right to name or right to portrayal. That would be not admissible, also not on copyright. But what you can invoke is non-registered trademarks if they are well-known trademarks, as you also referred to Article 6 bis of the Paris Convention. Other IP rights, such as geographical indications, and also we could invoke trademarks protected abroad at the bad faith ground. So we can include additional grounds, but not all that are mentioned on the slide, Paola.
Okay, thank you very much. Then the next question is a very practical question, because we asked if a formal notice of invalidity revocation is available, and in particular also if the full statement of the grounds can be filed at a later stage. According to the information we received, the formal notice can be filed only in Estonia and Benelux. As for Poland and Hungary, detailed argumentation can be filed later on. However, the legal basis of the invalidity procedure must be submitted at the beginning. For all the other countries, a full, complete claim has to be presented at the time of the filing, including the filing of all the documentation supporting the rights, the prior rights, if it is, of course, a relative invalidity action based. Coming to the fifth question, we asked if the registration is considered surrendered by default if the right owner does not reply to the invalidity revocation action. Here we have a very short and strict answer, that is that only Germany and Benelux have this decision by default. In all the other countries, the office is going to issue a decision. Then for the sixth question, we asked if invalidity and or revocation action can be withdrawn and without the consent or an agreement of all the parties which are part of the action. Here the answer is yes for all the countries, with one exception, which is Italy, where the action can be withdrawn, but if the other side is not accepting the withdrawal, the office is going to issue a decision. In case of this is valid for action before the trademark office. In case of court action, the action can be withdrawn without the need of an acceptance from the other side, only before the appearance of the defendant. After that moment, the acceptance is always needed. We have also a very peculiar, we just discovered that we have also a very peculiar situation in case of withdrawal of the registration, which is subject to the revocation or the invalidation, because in case of total or partial withdrawal of a trademark before the trademark office, our code provided for two different mechanisms of operation, depending on whether the withdrawal is made under a revocation procedure or under an invalidity proceeding. In the former case, revocation proceedings, in the absence of an express notice to the contrary from the petitioner, the effects of the withdrawal act remain suspended and the revocation proceedings will continue. In the second case, on the other hand, invalidity proceeding, in the absence of an express notice to the contrary from the petitioner, the invalidity proceedings are terminated, even if it is a partial withdrawal. So the next question was, next slide, please. If the new invalidity grounds apply to all marks, even if registered before the entry into force of the new provisions. The only countries where the answer to this question is no are Benelux, Estonia, Portugal, and Ireland. In Germany, the new grounds for invalidity, such as signs which are excluded from registration pursuant to German law, sign providing for protection of designation of origin and geographical indication, and so on, apply only to trademarks filed after January 1, 1929. In Spain, the answer is yes, but examination is carried out according to the amended Trademark Act. And in Czech Republic, if an application is filed for a declaration of invalidity of a trademark on the ground of its registration contrary to law, the registrability of the trademark should be assessed in accordance with the law in force at the time of the registration of the trademark. The above said, I'm now giving back the floor to Mara, who is gonna to highlight some main issues.
Thank you, Paola. Thank you very much. It really seems that there is no uniformity in how administrative invalidity and cancellation actions are handled and structured among member states. And there are even exceptions as far as mandatory grounds are concerned. You mentioned that in Italy, bad faith cannot be invoked at an administrative invalidity level, for example, even though this ground is expressly indicated by the directive, and this should not be the case, of course. You also showed us that there is very little uniformity as far as optional grounds are concerned. In this respect, I would also like to highlight another peculiarity of the Italian situation. We have some grounds, for example, the right to a name and the right to a portrayal, that peculiarly are available at an opposition level. So they can be invoked in opposition proceedings, but not in invalidity proceedings at an administrative level, which are handled by the same office. So this is indeed a peculiar situation for us. Another point of interest, again, is that very few countries have made the choice to make available a choice between the administrative and judicial route as a main claim. As you said, only Italy, Finland, Ireland, and then Germany only for relative grounds. What I would suggest to practitioners is in those countries to evaluate very well on a case-by-case basis the advantages and disadvantages of the respective route, also taking again into account the experience of the examiners at the IPO. And then again, I found very interesting even though we could not talk in detail about procedural norms, the fact that they vary considerably from jurisdiction to jurisdiction. Very few points can be taken for granted. As you mentioned, in Italy, again, once an invalidity or cancellation action is filed, it can be withdrawn only with the consent of the other side. Whereas the other aspect, which also was included in our IP regulation, what happens when it is the contested mark that is renounced. This is also on the one hand peculiar, but does not come completely something new, because it is similar to the practice that was recently changed at EUIPO level. So it will be interesting in some years when we will be in full swing in all the countries, also to see how many actions are filed, because if we look at the EUIPO as a benchmark, compared to oppositions, numbers are relatively small. But this is most likely because oppositions were available from the very start, from the very beginning, and also because renewal fees are sort of high compared to those at a national level. On the other hand, when we look at national registries, most of them have a considerable deadwood of non-used marks. And particularly in member states where oppositions were introduced only recently, I believe that these new procedures will be very helpful to enhance the trademark system, declutter the registry, and make clearance less burdensome for the practitioners. And as I was mentioning earlier, in Benelux, there is already some experience and some case law. So it would be interesting to hear how it was implemented there. And Carina, the floor is yours.
Thank you, Mara. And also from my part, welcome to everyone. And thank you to the EUIPO and to ECTA for inviting me today to present the Benelux point of view. So I think we can move now to the next slide. What I will do with respect to the Benelux, I will first give a general overview, also go over the principles, some statistics of last year, 2022, this year still, but close to the end. And then I will talk about some case law examples, both from the office, and also I will deal with 2 appeal judgments from the Benelux Court of Justice. So in the Benelux, we, following the directive, as Mara said, we needed to make sure we have an efficient and expeditious type of administrative proceedings, but we were also very efficient and expeditious in implementing the directive, because cancellation actions have already since June 2018 become available in the Benelux. So we do already have some case law and some experience in these type of actions. There is a very good website from the office, from the Benelux office, and I put in the link specifically to all information relating to the cancellation proceedings. You can find a lot of information on the website, also available in English. You can find copies of the decisions, the cancellation decisions, links also to the appellate judgments. So for any specific issue and information you need, I would certainly recommend to consult the website through this link, specifically thus for the cancellation procedures. The procedure itself, it's a very user-friendly, simple procedure to lodge the cancellation action. It is done by an online form. And so I did say that we have these type of actions since June 2018. But what was new this year is that there is now a separate form mandatory to be used whenever requesting proof of use. And this is not only in cancellation actions, but also in other type of actions. So this was new this year. And this is aligned actually with the EUIPO practice. And I think it's a good development, because then it's very clear for everybody involved in the proceedings that this proof of use is requested, and that this proof of use request is not buried within other type of arguments and could be overseen. So for that type of evidence, we need to file it through this separate form. Then we can go to the next slide, and the next slide is a very high-level overview of the principles. The cancellation action is a adversarial type of proceedings. We start from the presumption of validity of the Benelux trademark, and then it is very much an inter-parties governed type of proceedings. This means that both parties can, of course, submit their written arguments, but also it means that there is no own examination of facts by the Benelux office, or the Benelux office will not come up with its own evidence or its own documents. It's really up to the parties to build their case and to build their argumentation, which also means that if you do not explicitly dispute certain facts, they are assumed to be undisputed, and this can of course have consequences on the decision taken. So it's very much up to the parties, as I said, to build their case and to advance all arguments and to substantiate that, of course, with sufficient evidence. So that is what I wanted to say on the principles, and then we can go to the next slide, focusing on possible outcomes. So the possible outcomes, you actually have two phases, and then you have two specific cases at the end. You can, of course, have an inadmissibility decision. So that would be the first phase where the request is found inadmissible, and then there is no following substantive decision. If you pass that phase, then of course the substantive grounds are taken into account. But if you lack, if it lacks substantiation, so if you file the cancellation action through the formal notice, but then afterwards you do not substantiate it, then also this procedure will be set aside and you will not get a decision on the substantive issue. If the action is well-founded, the consequence is that the trademark will be struck from the register. It can also be partially well-founded, and then that would lead to limitation of the goods or services, or it can be completely unfounded, and then the trademark is maintained as it is already on the registry. The two specific cases then are the default judgment. Paola referred to it already in her overview. So if you have a lack of defense, then your trademark will be struck in the Benelux. And then the last option is, of course, it is a party-driven procedure, so parties can also agree to settle the case, and then the proceedings will be closed. So those are the possible outcomes in the Benelux. And then we can move to the next slide, and then I can talk about the statistics of this year. So the statistics go up to the 7th of December, so a week ago today. There were 20 cancellation actions decided by the Benelux office. And I've delved deeper into that and looked whether there is a majority on relative grounds or absolute grounds of lack or of genuine use. And it's actually quite split. So from the cancellation actions decisions, you have these three types of decisions, and it's more or less similar in terms of number of decisions regarding these three grounds. And in the case law examples that I will include, I will also discuss one on absolute grounds, one on relative grounds, and one of lack of genuine use. That is the Benelux office decisions, and these are also from this year. What we do not have in the Benelux as compared to the EUIPO is we don't have a Benelux Court of Appeals system. So if you want to file an appeal against a decision of the Benelux office, then you would appeal that decision before the Benelux Court of Justice within 2 months of notification of the decision. So from the Benelux office, you would go directly to the Benelux Court of Justice. Appeals are rare because only 4 appeals this year have been referred to the Benelux Court of Justice, and only 9 judgments have been issued in 2022. And when we look at the reversal rate, we see that the reversal rate is quite low. So in most instances, the Benelux Court of Justice upholds the decision of the Benelux office. And I must agree that in most instances, the Benelux office decisions indeed are of a high quality. So that was what I wanted to say about the statistics, and then we can move on to the next slide. And on the next slide, you will have an overview of the case law examples, which I will discuss. The first case was a case, I don't know if you recognize it without the name of the trademark. It is about a position mark held by Dr. Martens for the lace boots. It was a decision based on absolute grounds. And then we have a decision on supernova on relative grounds. And I thought, since we're in the Christmas spirit and the twinkling stars, that is apt to discuss that today. Then the last decision of the Benelux office is the Hyundai decision, and this one was on lack of genuine use. And then I will also deal with two cases from this year from the Benelux Court of Justice. The first case will only make sense to the Dutch-speaking participants. The trademark is "Ik wil van mijn auto af," and in colloquial English, you would say, "I want to get rid of my car," registered for car sales services, amongst others. So you will already know what the issue is there. And then the last decision is a very quite recent, still from the 18th October, the decision in Bobo Bird, and that is a decision on bad faith. And I included it not only to have a decision on bad faith, but also because this is one of the minority decisions of the Benelux court where it does reverse the first decision of the Benelux office. So without further ado, we will go to the first case law example on the next slide, where we see, you see on the right-hand side below the trademark, how it is depicted on the register. You can see that it's a position mark. It's a position mark, so the rest of the shoe is disclaimed, and the position mark is referred to as the yellow stitching on a black welt. So you can see the black welt just on top of the sole and the yellow stitching on this black welt for these lace type of boots by Dr. Martens. And the action was initiated based on absolute grounds. The petitioner held that this trademark lacks distinctiveness, that it would also have been a customary indication or become a customary indication, and also exclusion grounds were invoked, which is of course not surprising because we had on the other position mark for shoes a lot of case law on Louboutin. So here this case law is also reiterated on this position mark from Dr. Martens, and both exclusion grounds of technical result and substantial value were included, and that is of course a difference with the red sole position mark. So if we then go into the arguments, and we can find that on the next slide. The first argument that the office tackled was the customary indication. And there you can see, if you read the decision, that it is really important to substantiate and to argue well your case, because the office held, well, there are no indications of it having become this type of position mark, a customary indication for the type of goods. And they also said it's actually quite far-fetched. So a reminder for parties that if you want to invoke an argument, you really have to substantiate it well, because otherwise it will in any event be found not well-founded. Then turning on to lack of distinctiveness, and there was an agreement, and also the office said, yes, inherently there is not a sufficient distinctiveness for this type of position mark. But then when you turn to acquired distinctiveness, there indeed the holder of the trademark could convince the office that there is indeed acquired distinctiveness, sufficient acquired distinctiveness in the Benelux for the trademark to be maintained. And also there were some interesting arguments raised, and we can find those on the next slide. So with respect to acquired distinctiveness, of course, we are in the Benelux, and so proof should have been and was submitted about the prominent presence in the Benelux. Not only today prominent presence, but also going back decades. I think they had documents going back to the 1970s, the 1970s, and building up till today. Really consistent use of this trademark, of the position mark, and they have been able to provide press clippings, articles, really saying that this identifying feature, this stitching, yellow stitching on the black welt, is really what is the identifying feature of these Dr. Martens boots, and that it was, as I said, consistently used. And they had press clippings, including the words famous, striking. I see there was a typo on the slide, apologies. Distinctive, classic, iconic. So of course, this is the type of proof that will get you to an acceptance of acquired distinctiveness. Sorry. On the market surveys, because market surveys were submitted by both parties, and in the Benelux, we do use market surveys, but these market surveys are often frowned upon because they would say that the questions are leading, or that it's not sufficiently clear which questions are asked. And often you also have market surveys from both sides, and these market surveys then substantiate exactly the contradictory argument from both sides. So, and this was here also the case. There was inconsistency in the outcome of the market surveys. So the office put that aside. And also what was very important, these market surveys only covered the Dutch market, and we are in the Benelux, and the Netherlands is of course a big market. But in the Benelux, for acquired distinctiveness, your market surveys should also include Belgium and Luxembourg, so the whole of the Benelux markets. So the acquired distinctiveness was accepted by the office, but then of course it still had to look at the exclusion ground, because otherwise the acquired distinctiveness would not help to rule on the case. So we can go now to the next slide and see what they said about the exclusion ground. So if you remember, the exclusion ground was actually built upon two layers. So the one was the exclusion ground for functionality, so that it would be technical. And the other one was on the substantial value, as we had in the similar Louboutin case. On the technical function, it was all about the stitching of this welt, because the stitching is actually holding the sole together with the upper part of the boot. And it was said, well, this position mark, we need to be able to use that stitching, because otherwise you cannot attach the sole to the boot, or alternatively, you could use other things, but we know that alternatives are not sufficient. So the Benelux office said, yes, we can follow that part of the reasoning with the stitching, that the stitching has a functional effect, has some technical requirement there. But this is not the case for the position mark on the register, because you can see that what is claimed is the yellow stitching on the black welt. So the trademark is actually more limited than just the stitching and the welt where you can see the stitching. One of the essential features is also this color yellow, and this color yellow is certainly not of a technical character. It has no technical function. So on that basis, they excluded the application of this exclusion ground. And then turning on to substantial value, and this is also interesting because the office very clearly says, if you talk about substantial value of certain features or characteristics, then you should only be talking about those that are inherent to the goods and services. So that give a value, substantial value, intrinsically. And any value that has been derived by the reputation of the trademark, the reputation of the trademark owner, and to really the use of that trademark, that may not be taken into account on this ground of exclusion due to substantial value. So both exclusion grounds were dismissed. The acquired distinctiveness was thus upheld, and also the trademark has been upheld by the office. An appeal is pending, so watch this space. There will be another judgment on this, and I understand that the same issue on this position mark is not only pending in the Benelux, but in other countries as well. So there may be more judgments to follow. So that was the decision on absolute grounds. And then we can move to the next slide, and that deals with the case law example that I wanted to discuss today on relative grounds. On the left, you can see combined figurative word trademark with also a slogan below, Nova. And it was, amongst others, registered in class 31 for, or is registered in class 31 for fruit trees, apples and apple trees. And then you had the younger trademark Supernova, and also, amongst others, registered for fruit trees, parts thereof, and in particular apples. And also in class 44 with regard to multiplication, propagation of fruit trees, and again, in particular, regarding apples. So you had these two trademarks, and Nova, the holder of the earlier trademark, initiated this cancellation action on relative grounds. The Benelux office followed a classic approach of comparison of the signs, comparison of the goods and services, and then an assessment of likelihood of confusion. And we can go to the next slide where we see this comparison of the signs. Again, the signs, the intrinsic features of the signs from a visual, phonetic, and conceptual comparison. Visual, they said that if you take a look at the older trademark, the Nova combined figurative trademark, it ruled that both Nova as a word, but also since it was so highly stylized, the figurative elements were both dominant elements. You also had a slogan below Nova, which read with love for nature in Dutch. But this was held to be so small and also not quite distinctive that this slogan was not taken into account as a dominant element. And if you then compare to Nova, which is a Supernova, which is a word mark, but the complete word, or the word Nova, is completely encompassed in a Supernova, they came to the conclusion that there was a certain visual similarity. The same reasoning was upheld for the phonetic comparison. Also there, Nova and Supernova, it was held that they have a certain phonetic similarity, of course, because Nova is completely within the Supernova trademark. And then we can go to the next slide, and there we have the conceptual comparison. And whereas the Benelux Trademark Office held that the prior trademark, that people would know that Nova is new, that it's the Latin word for new. For Supernova, it was argued that only part of the public would recognize that as being the term also used for an exploding star. They elaborated indeed that not everybody would know that. That it would only be part of the public, maybe now more in the Christmas periods where everybody's thinking about stars, but only part of the public held the Benelux office knows that expression or knows that word. But the other part of the public would think that super and Nova was like a super new variety. So therefore, they said that the conceptual similarity is present for part of the public. Then it turned to the comparison of the goods and services, and then we can move to the next slide for that. And as you have seen, and as I've read out, you already know that part is identical. And then with the comparison, because the earlier trademark was only registered for goods in class 31, which I read, but the other one was also registered for some services, the Benelux office did confirm that goods and services can be similar when they are complementary. And so here you have a certain degree of similarity also between the goods and services, and for the goods itself, so you have part identity. So that's not a surprise then that at the likelihood of confusion, given this communicating vessels, this likelihood of confusion was established between the two trademarks. And what is still important in the assessment of likelihood of confusion is that here you have goods and services that are directed both to professional public, the people who buy these fruit trees to multiplicate and propagate, and to be in the business of growing fruit trees and selling of apples, but also towards consumers. And again, as also has been confirmed yet in EU case law, when you have this mixed public, relevant public from both professionals and consumers, you should take into account the lowest level of attention when doing a likelihood of confusion assessment. So likelihood of confusion established, and Supernova cancelled as a trademark. And then we go to the next slide, and that's the last case law example of the Benelux office. And that is a case involving the trademark Hyundai, which we probably all know for different types of goods and cars in particular. But Hyundai here had a Benelux trademark in class 9 for screens, for panels, pharma plasma display panels, LCD screens. And it was invoked that there was a lack of genuine use of this trademark. And again, it's a very adversarial type of proceedings. So as a trademark owner, when you are faced with a lack of genuine use claim, you should really substantiate that you have been using the trademark genuinely, consistently, and not only argue that, but of course substantiate that with sufficient documents, sufficient evidence, sufficiently clear evidence as well. And this was where this case got a ray in before the Benelux office. So the proof submitted consisted of only two invoices for screens that were purchased in the Benelux, in Belgium and in the Netherlands. One invoice going back to 2017, the other to 2018. Then there was also illustrations submitted of the use on the monitors. There were 2 pages of a catalog that had been submitted. Then links to just corporate website of Hyundai, but it was the corporate website from Korea. Then also links to the website selling these display products in the Benelux, but just the links to the website, not actual purchases on this website. And then we can move to the next slide. And I, of course, give it away already that this proof was held not to be sufficient. The office held that a sale of only 4 units over 5 years is really negligible. And what is important here is, of course, that you should take into account always the type of products, the type of goods that are at stake, because 4 sales over 5 years could be sufficient in another case, but not in this case, taking into account the nature and the pricing of the products. And also there were other issues with the evidence that was submitted, so as the lack of dates on the documents, or really an indication in the catalogs and on the websites that these goods are distributed within the Benelux, or even that they are targeted at consumers in the Benelux. So for that reason, the proof was held to be not sufficient. A last interesting point in this decision, and we can move to the next slide for this, is a discussion about evidence submitted or coming from a licensee. And the claimant in this case said, well, all this evidence that has been submitted through the licensee is actually inadmissible, because there is a lack of proof of the existence of a license, and licenses should be mandatory recorded to be enforceable towards third parties. So all these documents, we need to take these out of the case. We cannot take these into account. The defendant, on the other hand, the defendant did not agree, of course, and said, well, a recordal of a license is not mandatory in this case. It is mandatory when you have an enforcement case, but not in this type of action. And it also held that, of course, all use by the licensee does inure to the benefit of the trademark proprietor. What did the office decide? The office followed the defendant in this respect. It also held not only is there no need for a formal recorder in this type of action, but also that there is actually no need of a formal contract. There can be like a non-written agreement, a non-written license agreement. And really the factual analysis in this case, in this type of action is dominant, and that can suffice. So when we see that there are invoices submitted, issued by a licensee, that really implies this business relationship, that implies the license, and that can be taken into account in these type of actions. So those were the case law examples of the Benelux office, and then we can move to the next slide, which deals with the first case of the Benelux Court of Justice that I wanted to discuss with you today. So if you remember, ik wil van mijn auto af. So you have a little bit of Dutch course at the end of the year as well. It means I want to get rid of my car for class 35, amongst others, several services relating to car sales. This is a action based on absolute grounds. An action based on absolute grounds, and actually there has already been another action in this respect because there was also a provisional refusal at the time by the Benelux office, and at the time the holder of the trademark could convince the office that this trademark had acquired distinctiveness. The office, however, in this decision, which we are discussing today, did take another decision and struck the trademark. And of course, it is against that appeal, that decision, that the appeal was filed at the Benelux Court of Justice. So we have absolute ground claims claiming that this trademark is descriptive for these services. Ab initio, so it is descriptive as such, and that there is no acquired distinctiveness. What is also important is, of course, that this objection was in particularly raised for the Dutch-speaking part of the Benelux, and also, of course, in the case that we're now discussing, this is the relevant part, the Dutch-speaking part of the Benelux, because it is a Dutch phrase. So what did the Benelux Court of Justice decide, and that you can find on the next slide? So on the next slide, we see that there is a difference between ex parte and inter partes proceedings. So as I said, the Benelux office in the ex parte proceedings, where only the trademark proprietor was submitting arguments on the provisional refusal, came to a different outcome than when there was this other party that filed the invalidity action. And this is is just a result of the different type of proceedings. So the Benelux Court of Justice has held that this indeed can result in a different outcome, and that this is not contrary to legal certainty. There is, in these type of inter partes proceedings, a new assessment made of the case, a new assessment also made upon maybe other arguments or other documents, other evidence that has been submitted, or additional documents that have been submitted. And so a different outcome is possible and is not prejudicial to legal certainty. So that was the first important point of this ruling of the Benelux Court of Justice. And then we can move to the next slide, where we have another case law example from the Benelux Court of Justice, and that is about the Bobo Bird trademark. This is a cancellation action based on bad faith. It is about a trademark Bobo Bird for a type of wooden watches. So again, sticking with the Christmas spirit, if you want to still buy a Christmas gift, these Bobo Bird watches are available in stores. And the Benelux office held, while this Dutch distributor, there was no bad faith on his part to register Bobo Bird, but the Benelux Court of Justice did not agree and said there was bad faith and struck the trademark from the register. The principles in the Benelux Court of Justice decision are clearly set out and is in line with actually the European case law, where you have no definition of bad faith as such. And so they applied the principles from the Court of Justice case law. And they also emphasized, of course, that all factual circumstances are always very important in bad faith cases, and that bad faith should be assessed at the moment of filing of the trademark. So taking into account these principles, they applied the same to this Bobo Bird case, and we can move to the next slide. And so there was a distribution relationship between the Benelux trademark proprietor and Shenzhen Bobo Bird Limited. And what you see on this slide, on the left-hand side, you can see the trademark as registered not in the Benelux, but in China and other jurisdictions. Then you can see in the middle what the Benelux distributor had on his website. And then you can see on the right-hand side, the Bobo Bird, just the word trademark, that the distributor had registered. So the distributor was using the two right side signs, and the left hand side is from the original trademark proprietor. And so we can move to the next slide to understand the reasoning of this case. What had happened is that this Dutch distributor, he had knowledge of the use by Bobo Bird, of course, outside of the Benelux, because he was a distributor and he was in contact with them directly. What he also knew is that the trademark was at that point in time not yet registered in the Benelux, but there was an intention by this party to protect Bobo Bird internationally and including in the Benelux. And so the distributor said, well, I can register the trademark because I am the legitimate distributor in the Benelux, and I actually have authorization. And some emails were advanced in the proceedings, emails between the proprietor and the Benelux distributor. And actually from those emails, it could only be inferred that there is an authorization to use only Bobo Bird, not in the entire Benelux, but only for the Dutch market, so only in the Netherlands. And what could not be inferred, on the contrary, from those emails was that there was no authorization to file for any trademark protection within the Benelux. So the bad faith was upheld. And so the message from the court was really, when you claim that you have been authorized to file a trademark in these circumstances, you should have like a clear, explicit mandate to file that trademark. And also because in our jurisdictions, Belgium, Netherlands, and Luxembourg, we cover 3 countries, that authorization to file should be, of course, valid for the 3 countries. There should be explicit and unambiguous language in that respect, or otherwise this could be indeed considered a bad faith filing. And on the topic of bad faith, we will hear more now from Andrej, and I'm happy to pass the floor on to him.
Thank you, Carina. This was really the best cue for my topic. The Bobo Bird case actually has a lot of elements or factors of bad faith, so it's a perfect example. So hi everyone, my name is Andrej, and today I will be talking about the concept of bad faith and some recent developments regarding this question. As you can see on the index slide, we will first just briefly look at the directive and the definition of bad faith. And then we will look at the bad faith assessment factors and scenarios of bad faith as they were identified by Common Practice Working Group 13, working on bad faith. And then I will describe just 2 recent case law examples, which are very relevant at the moment, and some general rules for the finish. Next slide, please. So what is bad faith? All of us, especially attorneys, we know that when our clients see a similar trademark, they will immediately think that this is a theft of their ideas. And of course, they will come to us and say that, you know, bad faith here is very much obvious and everybody should see it. But we all know that it is not that simple. Bad faith must be properly proved and established by either courts or IP offices. So let's look at how this can be done and what are the factors of bad faith. Next slide, please. In front of you, you have two provisions of the Trademark Directive. There are two more provisions that are dealing with acquiescence, but these two are the most important ones. So Article 4.2 prescribes that all member states must include provisions in their national laws allowing invalidity of trademarks. So post-registration invalidity has to be allowed. This is a compulsory provision for all member states. But there are also some optional provisions, which is that the member states can allow also refusal of trademarks before registration, so in the examination or opposition phases. And there is another provision that allows also refusal of trademarks if they are copying trademarks that are protected abroad. According to INTA survey and a little bit of research that I did, opposition is available on this ground, on bad faith ground, is available in approximately 50% of member states. And in the other half, it is not available. Like, for example, Carina mentioned also Benelux, and it is, of course, not available in opposition proceedings before EUIPO. Even more rarely, it is possible to refuse trademarks ex officio by IP offices, so in the examination phase. These instances are very rare because bad faith would, in those cases, have to be very obvious. So prima facie, it would have to show that there is, the evidence would have to show, or behavior of the applicant would have to show that there is bad faith in the application. Next slide, please. The EU trademark legislation does not contain a definition or description of bad faith, as we already heard. So the concept of bad faith and how to apply it is left to case law. So one of the most important definitions of bad faith is the opinion of the Attorney General Sharpstone in Lidl case from 2009 that you can see in front of you. And as you can see, the opinion says that the bad faith relates to a subjective motivation on the part of the trademark applicant, a dishonest intent or other sinister motive, which will nonetheless normally be established by reference to objective criteria. So, in other words, the dishonest intention is a very important element, and it is crucial to establish bad faith. But this crucial intent or motivation, sinister motivation, has to be proved with some objective evidence. And later on, we will look into factors of how to prove dishonest intention. Next slide, please. As we already mentioned, I think Mara mentioned it already, or Carina was. Assessment of bad faith is done on case-by-case basis, and all circumstances of the case have to be taken into account. So there is no recipe, there is no exclusive list or exhaustive list of bad faith behaviors. Every case has to be evaluated on its own. At the same time, the concept of European Union, the bad faith in the European law, should be given a uniform interpretation. This is a guidance from the Court of Justice of the European Union, which is not exactly the case right now. So bad faith is interpreted or applied differently in different countries. In some countries, bad faith would be you would have to prove bad faith through proving very close relationship between the trademark holder and the, let's call him infringer or a person that is in bad faith. In other countries, a very simple presumed knowledge of a previous trademark, earlier trademark, would be enough to prove bad faith. So the practice in European Union right now is not very harmonized. What Mara already mentioned at the beginning is that some of the offices now will have to deal with invalidations based on bad faith for the first time, because Article 45 of the directive is supposed to be implemented in all of the countries by January. In some countries, it is still not. And this means that we might face a situation where interpretation of bad faith by IP offices that were not dealing with this question before could actually become even less harmonized. We could see even more different interpretation of this concept. So this is why a working group on common practices was established dealing with bad faith. And in November, I think the document, the draft document of Common Practices 13 was open for comments. I think the end of November, the time for comments ended, and I think that soon we will see the second draft and hopefully finally a final version of the document, which is an excellent document, which I really recommend you read. And it establishes and defines some factors which are important to assess bad faith, and is giving us some scenarios how to establish bad faith. This is all based on the court practice that we have available right now. Next slide, please. So now I will be talking about bad faith assessment factors. How do we assess bad faith? And this is all based on CP13 findings. Of course, as I mentioned, the mandatory factor is dishonest intention. So dishonest motive when you are applying for a when somebody is applying for the trademark. This is, without this factor, we can never talk about bad faith. Simple business motivations or competition, normal competition, would not be dishonest. So in those cases, we can never talk about bad faith. Other factors that I will be talking about might or might not be applicable. It really depends on the case. So this list is not really exhaustive. These are just factors that usually from the case law we would see as being maybe essential or maybe applicable to a certain case. So let's start with with applicants' knowledge or presumed knowledge of third parties, right? Which was also the case in Carina's example. This is a very important factor. Of course, if somebody knows about other trademark, even if it is applied or used outside of the European Union, and he applies for this trademark, it is quite clear that this is an act of bad faith. Usually that would be a very good indication. Especially in cases of trademark misappropriation, this would be almost an essential factor. The second factor that we should take into account is degree of legal protection. And what we mean by that is the, let's say, reputation or enhanced distinctiveness of an earlier trademark. So the more reputable, well-known, or distinctive it is, the more important it would be if it is copied. So in these cases, of course, we would have to also look into the reputation or renown of the earlier trademark. The next three factors are identity or similarity of marks or goods and services and likelihood of confusion. So contrary to what many people think, the identity of the marks or goods and services is not a compulsory factor. They do not have to be identical. The signs do not have to be identical. There does not have to be a complete copying of the sign. There has to be a certain link between them to establish bad faith, and it depends on the case how strong this link has to be. Likelihood of confusion is actually not a requirement, but if there is confusion, of course, that would already show that there is some sort of bad faith benefiting from the earlier trademark. Next slide, please. This is on the right side. You can see a very nice example of bad faith. It's not an EU case, but I think that the applicant in this case would have difficulties claiming that he did it in good faith, or that similarity with McDonald's is a coincidence. So let's move on with the next factor, which is a previous relationship between the parties. This is also in Bobo Bird case Carina mentioned before. This, of course, is a very important factor. So if we had a license agreement, a distribution agreement, employment agreement, or any sort of a relationship between the applicant and the owner of the previous sign or a trademark, this would be a very good indication. Actually, this factor is an upgrade of the knowledge about the previous trademark. So the relationship here is very tight. So if somebody is trying to misappropriate the trademark or usurp the trademark from the previous partner, that would probably indicate bad faith. The next factor would be origin of the contested mark and its use since creation. So here, what we would look into is how the trademark was designed, whether a logo, whether the previous owner ordered creation of the logo and then a licensee was using it, or somebody else got a license to use it. The history of how the logo was created would be relevant in these cases. The next element would be chronology of events leading to the filing of a trademark. So, for example, one of the examples would be if parties had a dispute, maybe before the application of the bad faith trademark was done when relationships were starting to deteriorate between them. Maybe the owner or rightful owner of the sign was in financial distress, so somebody tried to sort of use this situation. The next one is honest commercial logic. So this one is probably the most difficult to assess of all of them. So when a certain trademark application is not following legitimate business strategy, this is sometimes very difficult to assess or to find out. For example, a long list of goods and services in the application can serve to cover future growth in business, but on the other hand, it might also serve to block competitors. So, you know, this commercial logic is difficult to assess, and it is very difficult to see what was the mindset of the applicant at the time of application. The next factor that might be important is request for financial compensation. But here, it is really important to note that selling or trying to sell a trademark legitimately as selling part of the business is not prohibited per se. So if you're trying to sell a trademark as selling part of the business or trying to, I don't know, get into some sort of a license setup, that is not prohibited. But if you apply for a trademark exclusively because you are trying to sell it to the rightful owner and to block him until he does not buy the trademark, so to hold it for a ransom in a way, that would probably indicate bad faith, and it often does. Then the last one that I'm going to mention is a pattern of applicant's behavior or his action. So here, what we would look into is what the applicant is doing otherwise, outside of this trademark, for example. We all know of serial applicants that are constantly applying for trademarks and then they are trying to sell them to somebody else. So if somebody is doing this for a very often or for a longer time or in many jurisdictions, this would be very indicative of bad faith behavior. So with the next slide, I will start explaining some typical scenarios from the case law, which with CP13 working group also identified. So right now, from this court practice until now, we can split bad faith application scenarios into two types, or as CP13 working group calls them, facets. The first ones are applications with intention to misappropriate third parties' rights. And the second ones are to abuse trademark system. Under misappropriation, we will talk about parasitic behavior. So these are free ridings on reputation, which also includes residual or surviving reputation from the past use. And this will also apply for rights of non-EU origin. The second example of misappropriation would be if you're trying to benefit from an earlier right as well, also outside of the EU, which was from reputation that was gained through use outside of EU. And the second point would be breach of fiduciary relationship with the intention of usurping others' rights. So you would see a Gruppo Salini case here. Next slide, please. The second facet, or second type of scenarios, which also show different type of let's call it dishonest intent, is abuse of trademark system. Here we would have three different types of abuses that were identified. The first one is defensive registrations without honest commercial logic. So this would be trademarks that are applied in order to artificially extend the level of protection. So example would be Target Venture case, where the owner had a different trademark containing the word Target, but they applied for Target Venture because they wanted to enhance the protection of Target trademark. They artificially tried to create a family of trademarks to enhance the protection, but they did not have intention to use this trademark at all. The second example, which I will mention more a bit later, is refiling with intention to abuse the trademark system. So these are refilings that in most cases, or at least in monopoly case, would be to avoid the requirement to prove use. Because as we know, we have a grace period of 5 years for non-use. Validity is presumed for 5 years, and after that, the trademark can be cancelled on non-use. So very often in practice, we would see that trademark holders are reapplying for trademarks to extend this 5-year period. And the last example would be speculative purposes as an instrument of leverage. This is a Luceo case. Here, for example, we will talk about blocking other parties, applying for a trademark to block other parties and then to try to sell it, for example, and which was the case here. Next slide, please. Now here, this is a case, a very nice case, which I chose because we are now in the World Cup season. Don't worry, Neymar over here is not really suffering. This is one of the examples of him overreacting during the last World Cup. He was not really injured here, but he was injured by trademark applications or trademark registrations of a Neymar trademark in Europe. the trademark actually was applied in 2012, not 13. And it was applied or registered by a person that is not related to him. At that time, Neymar was not yet playing in Europe. He didn't join Barcelona club yet, and he didn't have any prior trademark rights. So essentially, he didn't have any protection here. But he did prove when he filed invalidity action that he was known already internationally. He was playing for a Brazilian national team. People knew about him, even though he was not playing in Europe. And during the procedure, it came to light that the applicant actually knew about the world of football. So he also was applying some other trademarks like Iker Casillas, which he did actually on the same date. So this is a good example of how behavior of the applicant would come to light or would become an important factor. Of course, in this case, the Court of Justice, and before that, the cancellation department of EUIPO decided that this was a case of dishonest intention to create an association in order to benefit from reputation, even though that reputation was a result of playing outside of the European Union. Next slide, please. So this case is a case of a scenario of bad faith because of abuse of law, or in order to abuse law. This is a very famous case, a monopoly that actually caused a lot of, a little bit of a stir in IP community, and it's slightly controversial in a little bit of the reasoning. In this case, just to explain the background a little bit and very shortly, Hasbro actually already had 3 trademarks, older trademarks, and then they reapplied for a monopoly trademark that covered the list of goods almost identical to those 3 older trademarks. During the hearings and during the procedure, it came to light that one of the reasons or one of the benefits that Hasbro found for reapplying the trademark was to avoid the obligation to prove genuine use in opposition proceedings. So they wanted to artificially extend the 5-year grace period. The conclusion of the General Court was that refiling is not prohibited per se, but if you do so to avoid obligation of proving use is abuse of law. It is contrary to the provisions that are regulating proof of use as a defense in opposition cases or invalidity or infringement cases. So this was, in their view, dishonest practice, contrary to the principles of law, and they invalidated the trademarks for all the goods and services that were already covered by older trademarks. What they did is they left the trademark in force for the goods and services which are different from the old trademarks, because here they believed that the legitimate interest was to, let's say, modernize the list of goods or to adjust the trademarks to the new technologies. Now, why is this case a little bit controversial? So, I mean, there are several things that are being discussed in the IP community, but mostly what seems to be the problem is that monopoly trademark is one of the most famous trademarks. We all know it. It is actually used for at least big part of the list of goods and services that were the subject of invalidity here. So this trademark of this type, this particular case, it requires a lot of enforcement. against infringement cases. It requires a lot of oppositions. It requires a lot of action from monopoly, from Hasbro. And the problem is that if in each of those cases, proof of use is requested as a defense, and that request for proof of use is in itself abused, the concept of the legal concept or defense institute is abused to delay proceedings or to put pressure to exhaust the plaintiff, then this actually becomes a problem in itself. Because what the court said is that the reduction in administrative burden by not being obliged to prove use is not justified. It's not a legitimate reason. But on the other hand, there are no provisions that would prevent abuse of the request for use as a defense. So we now have a problem where Hasbro has to prove, for example, or in similar cases where we have a very famous and widely used trademark, Hasbro would have to use, or a trademark owner has to prove use in many proceedings, which can be extremely costly. And I think that this maybe is a little bit controversial because it does say that refiling of a trademark to avoid this obligation to prove use of a trademark that actually is being used is bad faith behavior, but maybe it is still a legitimate or a justified reason for reapplying a trademark only in cases where a trademark is actually used. Next slide, please. So just to conclude with some general rules regarding bad faith, in principle, burden of proof is always on the claimant, but in certain cases, it can be reversed. For example, if IP offices would believe that that there are reasons maybe to refuse a trademark, they would ask the applicant to prove that he had good intentions. So they would allow him maybe to prove otherwise, that the evidence before IP office is maybe incomplete. The second principle or a general rule that is important is that even according to the trademark directive, there is no acquiescence to use of a trademark that was applied in bad faith. And in some member states, there is also no statute of limitation for invalidity of trademarks filed in bad faith. The relevant time would be the time of trademark application, but circumstances before and after trademark application can be relevant to interpret intention. So dishonest intention or a sinister motive. This can already show in certain actions before or after trademark application. The applicant can be a person that is actually acting in bad faith, or they can be linked to an actual person that is trying to harm. It can be either a manager or a linked company and so on. And as we already mentioned during today's presentation, the outcome can be a partial refusal as well. This was, I think, also confirmed by the court in Sky case. So if bad faith is proved or established for certain goods and services, the trademark will be invalidated or refused for those goods and services only, and it will remain in force for the others. And with this, I come to the conclusion of my presentation. Thank you for listening, and we are, of course, always available for any questions that you might have.
Thank you, Andrej and Carina. Are there questions? I see.
Well, since there are no questions from the public, I did have a question because, well, we in the Benelux, we've been used to this system now for quite some time. And there was some criticism, or people doubted that it would be as efficient as court proceedings. So people had some doubts. So I wondered, you are now both from Italy, Amara and Paola, and you're on the verge of starting the system in Italy. Do you think it will be a success? Do you think people will see it as an opportunity and wait now to file their action until it becomes available in January? Or will they be more reluctant and wait for the first decisions to come out? If you can say something about that.
Well, yes, I do feel like answering this question. And before, I am happy to share some statistics in other countries of the number of administrative actions that have been filed since the implementation of the directive. Like in Germany, it's approximately 250 per year. But what is striking is France, because France did not have administrative proceedings earlier. So let's say users were not in a habit of filing these kind of actions, and still they have like 1,000 overall from 2020 to date. So that's a large number. And I really do expect that Italy may do as well, because Italy is one of the countries where, as I was saying earlier, there is this really large deadwood of non-used marks. So I think that users may want to take advantage of the cancellation actions on a administrative level due to non-use. I am not as sure when it comes to invalidity actions, though. So this is my guess. I'm happy to, let's say, meet again in some years and see how things went, and maybe share case law and even the same case treated in different countries. So we'll see. May I also take the occasion for two things? Well, I wanted to thank Carina and Andrej, because you gave us a very good overview and allow us as professionals to form like better ideas on what to argue, or sometimes not to argue, in cases similar to the ones that you presented. And on a personal note, I found very interesting the case in which the substantial value of the Dr. Martens mark was discussed, because I think this is indeed a tricky provision. It is very, very easy to see substantial value in what it really is the goodwill that the trademark owner built on the trademark by using it. So I think that this understanding of your Benelux office IPO, that substantial value that can lead to invalidity is only the one that is really intrinsic to the good, is very good to hear. Is something that's nice to hear for trademark owners and those who represent trademark owners. And Andrej, thank you for sharing. You were very generous in sharing advice on how to argue bad faith, because most of us have very little experience, so it was nice. And it also to hear so much in detail about monopoly, because you are correct that it gave rise to, it's controversial, the interpretation was controversial, it gave rise to a lot of discussions in our community. So thank you for that. Thank you.